Hello, welcome to another immigration art video. My name is Art Serratelli, and together with Mara Mijal, the two of us, we run the immigration law group here at Serratelli Mijal, PLLC. If you've got a question, we'll have an answer. Send us an email. Email is your best bet. We get messages on social media. We get voicemail. We get email. We get text messages. To consolidate all the sources of messages into one place, that one place is email. We use email like other people use the phone. So send us an email. You can send me a text. If you've got a question, we'll have an answer. The subject of today's video is causing a lot of anxiety, fear out in the immigration community, particularly among skilled workers and students. There are two rules, and anyone who's showing you videos on YouTube or posting stuff on the internet and they claim that they have the answer, the magic solution to all this, they don't. Nobody knows what's going on because the government has only announced a policy. It has taken no actions yet. So, I'll tell you what the two rules are. I'll tell you what they mean in a nutshell and give you some general guidelines now until we learn more later about what the government's really doing. New policy number 1. If you submit an application that is incomplete or if it's missing significant evidence, they're going to just deny your case without giving you a request for evidence or without giving you a notice of intent to deny. Now, this policy could be sinister, and if Trump is behind it, it could be very sinister, or it could be common sense and justified. Justified. What does that mean? If people are filing sloppy paperwork and they don't fill out the application completely, or if they don't read the directions and give the government all the evidence they need, then why should the government go back through your defective work and tell you what you did wrong? The government is simply saying, hey, if you screw up, don't make me do extra work for your lazy, sloppy effort. I'm not doing extra work. I'm not your mother. And that's fair. That's fair. The sinister interpretation is, this gives immigration a free rein to just indiscriminately call anything they don't like incomplete or filed with insufficient evidence, and therefore they could just deny cases out of the blue without asking for more evidence, without giving you the opportunity to fix some oversights. What is incomplete? What is missing information? Who makes those decisions and what motivates them? That's what we don't know. And if any attorney is telling you they do, they're full of baloney. They don't know. Nobody knows. Rule number 2, new policy number 2. If you file a case to change your non-immigrant status from student to worker, if you file a case to extend your H-1B to get more H-1B time, if you file a case to become a permanent resident, and if that case gets denied, and if your underlying status expires, then immigration has the right to mail you a notice to appear for a deportation hearing. That is some serious stuff. So what does this mean? If you're a student and you're trying to change your status to H-1, do not let your F-1 student status expire. Don't do it. No. If you're on OPT and you're waiting for a cap-gap extension and you don't get an answer approved or denied, and your OPT is going to expire and your grace period is going to expire, and you asked for an H-1B but you have gotten no response from the government, you better not let that F-1 expire. You better not. So that's one example. Another example, you have H-1B. You want to extend it to get another H-1B. And there used to be this nice rule, it's still a rule, that says if you file for your new H-1B extension before your old one expires, so your old status expires here, you file for the new H-1B here. When the old H-1B expires, you're allowed to stay and work until your case is approved. But if your case gets denied, in the olden days, they gave you a chance to leave the country. Now, if you let that first H-1B expire while you're waiting for the approval of the second one, the extension, and the extension gets denied, then you know what? They're going to put you in deportation proceedings. If you were here working as an H-1B or an L-1 and you file for a green card, and that green card gets denied, you better have underlying status or you're going to be put in deportation proceedings, according to the new rule. So what does that mean? It means if you take the two rules together, A, you could file a case that you think is complete and contains all the evidence. The government looks at it and says, this is garbage, denied. And then you get a denial letter out of the blue, and you're also going to get another letter that says, by the way, you're in deportation proceedings now. You can't leave, because if you leave, you're going to be barred from ever coming back for 5 years. And if you stay and wait for the deportation proceedings to proceed, you might not see a judge for over a year, maybe more. And guess what happens during the time you're waiting to see the judge? You're accruing unlawful presence time, which will give you a 10-year bar. So the most sinister interpretation of these two rules together is that, one, a good case will be denied for no good reason out of the blue because it's incomplete or the evidence is missing. And on top of that, on top of the insult of the denial without any notice, you'll get deported too. Welcome to Trump world. Welcome, welcome everyone. Not with Donald Trump. Screw everybody. Donald Trump. Donald Trump. No good. So what do you do? What do you do? Be careful. Be cautious. Plan ahead. Don't wait to the last minute. Number one, and I'm reading this right off my Facebook page. We've already posted all this stuff all over social media. Facebook under my name, Art Serratelli. Facebook under the law firm page name. We posted it on Google+. We posted it on LinkedIn. We posted it on Twitter. We posted it on Instagram. On Instagram, this is all listed under a picture of Sarah Sanders. Mrs. Sarah Sanders Huckabee. I have a crush on her. I love the way she does her job. That's a very hard job, talking and defending the president every day to a world of educated, rational people and saying uneducated, irrational things. She does it really well. Here's what we say. Again, these are not rules. They're just common sense based upon what we know now, okay? Number one, you must not wait to the last minute to file a case. You want to make sure that you can file for your change of status or your extension of a status well before, as far in advance as the law allows, well before your current status expires. With H-1Bs, it's 6 months. Can you plan ahead, please? Can you ask your company to put you in line 6 months before your current status expires? That's what you must do. No complaining, no whining, no excuses. Do it. Number two, and again, I'm reading this right off Facebook. Number two, you better file every darn case with premium processing. Yeah, does it burn your hide to give the government an extra $1,225 to do their darn job in a timely fashion? Does it make you angry? Yeah. It makes me angry, and it's your money. But do it, because you're going to get an answer. Whether your case is approved or they want more information, you'll get an answer in 2 weeks. 2 weeks, not 2 or 3 or 4 or 5 or 6 months. 2 weeks. Do it. What else? Let's take a look. Number 3, if your underlying status is going to expire, and if your pending case is not yet approved, then the easiest way to avoid a denial and deportation is to leave the United States. If you're not here, they can't deport you. So if you have a pending case, and you didn't get an answer yet from immigration, get out. And then, if your case is approved, hallelujah, you go down to the United States Embassy where you live, walk into the consulate with an appointment, and get a new visa for your status that was applied for in America, and now you'll get the visa to go with it, and come back. Is that going to be a pain in your neck? Yes. Is it an extra cost? Yes. Is it going to put you and your employer at a disadvantage? Yes. Yes. All these things are not great, but it's all we got now until we see what's going to happen. The only other thing I put on Facebook is these general rules need to be tailored to the kind of case you're filing. If it's a marriage case for a green card, your behavior and your level of risk tolerance will be different than if you're applying for an H-1B or an L-1A. Or some other work status to extend. If you're changing from F1 student to a work status, well, that's a whole nother set of variables to weigh. And if you're changing from student to green card, that's even another set of variables to weigh. So there is no one answer. There is no perfect answer, because right now nobody knows anything. And do not pay a lawyer. Do not pay a lawyer to go discuss this, because what they're going to tell you is a bunch of baloney. At this point in time, nobody knows. The American Immigration Lawyers Association is still trying to figure it out. If the American Immigration Lawyers Association doesn't know, the lawyer you're talking to does not know. You're not helpless. You're not powerless. And we can beat Trump at his own game if you can bear the extra burden of perhaps traveling home to see your family when you didn't need to. If you can bear the burden of extra risk, or if you can bear the cost of extra expense to avoid risk, if you can tolerate that, all your friends that are U.S. citizens, tell them, vote Trump out. He's no good. No good.